Hi everyone, this is a Barclay Damon live broadcast where we discuss all things L&E, labor, and employment. I'm Ari, let's dig in. Hey guys, welcome back. I am coming in hot today on a special episode. The Supreme Court of the United States strikes down the OSHA Vaccinate-or-Test rule, but allows the CMS mandate to proceed. If you have listened to our prior podcast, we have told you pretty much everything you need to know, both about OSHA's mandatory vaccination or test out rule and the CMS mandates. We got some really important updates from the United States Supreme Court last week. Before we dive in, if you are watching this on YouTube, I will apologize in advance for my formal appearance today. I had a couple of court appearances this morning before I recorded, so that's why I'm looking a little bit more fancy than I usually am. And, people that know me know that I am a SCOTUS nerd. If you follow me on LinkedIn, you will see that my cover photo or my background photo is a picture of me in front of the doors to the Supreme Court. So, as I was thinking about recording this episode, I was pretty excited because this really speaks to my inner interests. But, I'm keeping in mind, calm down, Ari, this is not a Supreme Court related podcast. So I was going to skip today telling you something fun or interesting about me, but it looks like I just shared something interesting about me, or at least what I like to think is interesting, but I think that the jury's out on that. So, but anyway, guys, let's just dive in and let's talk about these two decisions. So let's talk about the Supreme Court's decision as it relates to the OSHA rule first. As I mentioned, if you listen to our first few episodes or the episodes that we had with Mike Sciatti, we really took a hard look at all the OSHA requirements and we really went through all of those requirements. So as our listeners know, the OSHA rules basically said that if you had 100 or more employees, you had to implement a mandatory vaccination policy or a weekly test out rule with some limited exceptions that, we went through in pretty good detail. On the episode with Mike Sciatti, we also talked about, the status of the litigation at that time. So just as a refresher, last time we spoke, the Sixth Circuit had issued the previously issued injunction on the OSHA rule, basically citing, the increased risk associated with the spread of COVID and resulting deaths due to the Omicron and Delta variants. As we let you guys know, the court heard oral argument on the case on January 7th and issued its decision last week on January 13th. So the name of the case is National Federation of Independent Business versus Department of Labor. And what you guys need to know essentially is this. A 6-3 majority of the court struck down OSHA's rule, basically calling it a blunt instrument that exceeded OSHA's authority under the Occupational Safety and Health Act and its regulations, and basically emphasized the fact that the OSHA rule drew no distinctions between different industries, different professions, different types of employees. Basically the court acknowledged that under the Occupational Safety and Health Act and its regulations, OSHA does have the authority to enact workplace safety standards, but OSHA does not have the authority under the statute and its regulations to enact broader public health measures. So, basically the Solicitor General had argued that, the risk of contracting COVID-19 in the workplace is a workplace safety risk or should be addressed by OSHA's workplace safety standards, because it really is a danger or risk associated with being in the workplace. And basically the court did not buy that argument. In fact, the court said, and I'm quoting here, although COVID-19 is a risk that occurs in many workplaces, it is not an occupational hazard in most. The kind of universal risk is no different from the day-to-day dangers that all face from crime, air pollution, or any number of communicable diseases. So essentially, the court said that, this was beyond OSHA's authority to issue this type of mandate because this really is in the realm of public health, is really not a workplace safety related standard, or is not a standard that is aimed to reduce risk in the workplace. So definitely, in my opinion, a kind of interesting take. And what was interesting is that the court also basically said that this mandate or this rule was not similar to other, workplace safety standards that OSHA had issued in the past. So, our listeners or employers that are covered, employees that are covered by this mandate, it really is a novel or a more far-reaching mandate than OSHA really has issued in the past. And the court basically, said a vaccination, after all, cannot be done at the end of the workday. So, essentially the court really took a hard look at OSHA's authority, or its OSHA's explicit authority under the statute and also the regulations, and basically said that OSHA exceeded its authority in issuing the mandate. If you're listening to our podcast and you've listened to other podcasts, you're probably wondering, okay, great, what's next? So I wanted to know, and I think it's important to know, that this decision issued by the Supreme Court is not the be all end all as it relates to these issues. And in fact, the court's opinion at the end directed the Sixth Circuit to resolve the merits of the case, and basically the stay is in place until the merits of these issues are addressed by the Sixth Circuit. I also wanted to point out that while the OSHA ETS mandate at this point is stayed, nothing prevents an employer who wishes to enact a mandatory vaccination policy from doing so. If you are one of those employers, definitely take a listen to our last episode. In our last episode, we talked about what to do if you're an employer and you want to enact a mandatory vaccination policy, but you're not covered by OSHA's rule or the CMS mandate. So, that episode, if you are an employer, you've already gone through, all of the requirements of the OSHA mandate, and you want to continue with having a mandatory vaccination policy, you are able to do so, provided you do provide for the exemptions that we've discussed before. So definitely take a listen to our last episode if you are an employer and you're kind of wondering what you can and what you should do next. Okay, guys, so let's transition now to talking about the court's decision as it relates to the CMS mandate. So, the court basically went the opposite way in issuing its decision or opinion in the Biden v. Missouri and Becerra v. Louisiana cases, one opinion addressing the issues in both of those cases. And basically what the court said, and we'll get into it a little more detail, is that, the CMS mandate can proceed. So if you listen to our third episode, I talk with Maggie Soroka about the CMS mandate requirements, as well as if you're in New York, the New York vaccine rules. And basically the CMS mandate says that if you're a covered healthcare facility and you receive Medicare or Medicaid funding, that staff within the facility need to be vaccinated for COVID-19. So, in examining these issues, the court did go the opposite way of the way it went in deciding or analyzing the OSHA rule. And, there were a few reasons for that. So basically, in this decision, the court held that in contrast to, the authority that OSHA had in the context of the OSHA rule, the Secretary of Health and Human Services has the express authority to promulgate regulations that the Secretary finds necessary, in the interest of the health and safety of individuals who are furnished Medicaid and Medicare services. And basically, the court noted that the Secretary had found in, its research and analyzation that the COVID-19 vaccine mandate would substantially reduce the likelihood that healthcare workers would contract COVID-19 and then, spread COVID-19 or give COVID-19 or transmit the virus to their patients. And as a result, in the Secretary's view, the mandate was necessary. So, basically the court noted that unlike the Occupational Safety and Health Act, here Congress authorized the Secretary of Health and Human Services to impose conditions on the receipt of, benefits or those individuals who are receiving services that receive Medicare and Medicaid funding. And, basically the court recognized that COVID-19 is a highly contagious disease, and that, the Secretary made a determination that a COVID-19 vaccine mandate would substantially reduce the risk of the spread of it. And, the court, also noted that the Secretary concluded that a vaccine mandate is necessary under these circumstances, as we just discussed a few minutes ago, to, decrease or prevent the spread of COVID-19 among, staff and also among patients who are receiving Medicare and Medicaid services. So, definitely the court relied on, express authority, or in the court's view, express authority that is conferred upon, the Secretary of Health and Human Services under these circumstances. And, the court did acknowledge that this mandate, does go farther than what CMS has done in the past or what the Secretary has done in the past. But with that acknowledgement, the court also recognized that, this particular pandemic or the circumstances surrounding this pandemic are really, novel. And, that is probably the reason why, these issues have not come up before. And, basically the court also acknowledged that the standard in analyzing the mandate or the decision to implement the mandate is one of arbitrary and capriciousness. And in the legal world, that's definitely a specific term or a term of art. But here the court said, yes, that's the standard, but it cannot be said that the secretary, failed to examine the relevant data. And, the secretary did also consider that the rule might cause staffing shortages, particularly in rural areas. And we talked about that with Maggie Soroka as well. But really the standard is whether, the decision to implement the mandate was reasonable, and the court basically determined that it was. So, this is a little bit different, of course, than the way the opinion turned out on the OSHA ETS vaccination mandate. But, I don't think it's particularly surprising, especially given that the Supreme Court has heard challenges to, state vaccination rules or laws or mandates, including, in New York. So not a huge surprise here, how the court ruled, just given how the court has treated other challenges to similar vaccination mandates. So, if you're listening to the podcast and you're a healthcare provider, you're probably wondering what's next. If you're in New York and you're a provider, the chances are that you're probably already complying with the mandate because of the New York vaccine rule. But, CMS did issue updated guidance in late December, basically saying that, the timeline had shifted a bit. The updated guidance by CMS says that, employees covered under the mandate have to receive at least the first dose of vaccination by January 27th, and that by February 28th, 100% of employees at covered facilities need to be vaccinated. So like I said, definitely take a listen to our episode with Maggie Soroka as it relates to the New York vaccine rule. But again, unless you're, a very specific subset of healthcare providers, you're probably already complying with the CMS mandate. So guys, that's everything I wanted to tell you today, everything I wanted to go through in these opinions. Definitely really important news if you're an employer covered by either the OSHA rule or the CMS mandate. But, just to reiterate, this is not the be all end all. As we mentioned a few minutes ago, the court directed that the Sixth Circuit hear the OSHA rule, and the lower courts will also need to address the merits of the CMS mandate. So, as of right now, the OSHA rule is stayed and the CMS mandate is permitted to, move forward. But we definitely anticipate that these issues will come up again. So, we'll do everything we can, of course, to keep you informed. Definitely take a listen. Next week, we're going to go through all the requirements of the New York mask mandate. And as I mentioned before, if you are an employer who is subject to the OSHA rule, definitely take a listen to our prior episodes. You still have the ability to enact, a mandatory vaccination policy if that's something you want to do. Thanks so much for listening, guys. I'll see you next week.
The Labor Employment Podcast is available on barclaydamon.com, YouTube, LinkedIn, Apple Podcasts, Spotify, and Google Podcasts. Like, follow, share, and continue to listen. Thanks. This material is for informational purposes only and does not constitute legal advice or a legal opinion, and no attorney-client relationship has been established or implied. Thanks for listening.